is Friday, 11:30, and it's time for another Ask an Attorney Live installment. And we're going to continue talking about DTPA and ways you, as a business owner, can get into trouble under the DTPA if you do certain things. Um, I always feel it's the best to educate yourself on ways to keep yourself out of trouble and out of the courtroom so that you don't have to spend a lot of money on legal fees. Um, so last week we talked about the first five, and today we're going to take another group of them. The first one is representing that goods are original or new if they are deteriorated, reconditioned, reclaimed, used, or secondhand. Um, Obviously, you shouldn't say something is new if it's not new. That's a pretty easy one to know, and it's pretty self-evident that that shouldn't happen. If it ever does happen, it's really easy for the consumer to prove that you knew that that item wasn't new. And the only way that you could probably get out of that is if somebody had represented to you when you purchased it that it was new. And then you would have to go after them. So it's always good to make sure that you're doing business with reputable vendors that won't tell you something's new when it's not, so that you don't get in trouble representing to your customers that something is new when it's not. Next is representing that goods or services of a particular standard, quality, grade, or if the goods are a particular style or model, if they are in fact something else. Another one that's pretty easy is, you know, don't say that you have a Lexus when you know it's a Toyota. Um, so just don't have any product that you say is a name brand when you know in fact it is not. That's another easy one for the consumer to prove in court that you knew. And when they can prove that you did something intentionally or knowingly, they get 3 times the damages. So if they paid something that was, paid you $500 for something they thought was new or was a name brand when in fact it was used or a refurbished or not of that name brand, then you could actually end up owing them $1,500 for that misrepresentation. So it can get pretty expensive, plus attorney fees. Let's not forget that one. So if they have attorney fees, you would be responsible for those as well. So another way you can get in trouble is disparaging the goods, services, or businesses of another by false or misleading representation of facts. This would be saying that your competitor cheats their customers and you don't have any actual knowledge or basis for that statement. They can actually, the consumer can sue you, and you can also get a defamation claim from the other business that you are making that statement about when in fact you have no knowledge of its truth. Now, if you have knowledge of its truth, it's not a problem. But if you know and you say that something or another business is doing something that you know that they're not, or you have no way of knowing whether they are or not, it can get you in trouble. So be careful with that. Advertising goods or services with the intent not to sell them as advertised, and that kind of goes along with the next one, which is advertising goods or services with an intent not to supply a reasonable, expectable public demand unless the advertisement says there's a limited quantity. So this comes around a lot on Black Friday. So you'll always see in these advertisements for, that fancy TV that's normally $1,000 is going to be $200 this one day, and you'll usually see in very small print, limited quantity. Sometimes they'll even say how many they have, and so they're not violating the Deceptive Trade Practices Act when they in fact tell you that there is a very limited quality. These two kind of cover the typical bait and switch, where they advertise, name brand item, and then when you get in there, they're actually selling you an off-brand item in its place. So don't want to do those two things if you own a business. Make sure to always cover yourself if you're giving a really good deal on something and you only have one or two, that you advertise that it's a very limited quantity. Making false or misleading statements of fact concerning the reasons for, existence of, or amount of a price reduction. So that would be you give a really good price discount and maybe it's because there's a damage or scratch to it, and you don't say that there's damage or scratches to it. Um, and so you're saying we're just giving this good deal out of the goodness of our hearts, when in fact you know that you're discounting it for another reason. So you want to be very, very honest about why you have a price cut or a reduction, and make sure that you're not saying anything that's not true. Um, let's see, next. Representing that an agreement confers or involves rights, remedies, or obligations which it does not have or involved, or which are prohibited by law. Pretty easy. Um, don't tell somebody that they're going to have all these warranties for a certain amount of time, when in fact there are no warranties, or the warranties are for a shorter time. That's going to get you in trouble. Um, and a lot of businesses believe that, having a written contract that says there's no oral agreements will protect them, but that's not always the case. If they can in fact prove that there was a representation made to them, and that was something that was a major factor in their decision to purchase that item, then they do have a claim under the DTPA. So make sure that you don't tell them and promise them something that's going to be beyond what they're actually going to get under a contract or an agreement. Knowingly making misleading statements of fact concerning the needs for parts, replacement, or repair services. The best way I can describe this is, you go into a car repair shop, and they tell you that you need all these things, repairs made to your car, when you actually don't need them. I recently was told I needed a whole new set of spark plugs when I didn't actually need any, because I had just replaced them a few months ago. So that's kind of an issue. So if you ever sell something to somebody that they don't need, and you tell them that it's something they absolutely need, it can get you in trouble. Here's a big one: misrepresenting the authority of a salesman, representative, or agent to negotiate the final terms of a consumer transaction. So this would be, you have an employee that enters into a contract that they don't really have the authority to enter into on your behalf. So this can be really troubling for a business owner, because if you have a employee that does this, you actually can be held accountable because that employee works for you. It's called an agent liability. So you want to make sure that everybody that you hire knows what they're allowed to do and what they're not allowed to do, and that you may find yourself having to be bound to a contract that you would not have entered into yourself, or you had no knowledge of, just to avoid triggering the Deceptive Trade Practices Act against you and your business. So it's very important to know who you're hiring. On another installment, I'll talk about a process that I use to hire that works out really well for me. And I don't mind sharing it, because I think it's a great process that I go to. We'll do one more. So, basing a charge for the repair of any item in whole or in part on a guarantee or warranty instead of on the value of the actual repairs made or work to be performed on the item, without stating separately the charges for the work and the charges for the warranty or guarantee, if any. This comes in a lot if you have a warranty that covers parts, but maybe not labor. You want to make sure that it's very clear that the pricing and the services that are going to be provided that fall under a warranty, you have to lay out what those are. And then if there are any other charges that aren't going to fall under the warranty, make sure that they're in a separate section, and it's very clear that those two things are separate. If you start mushing things together and not being really clear, you can fall victim to being sued under the DTPA, which, as you've heard repeatedly from me, you could be looking at triple your damages. So it can get quite costly. So we also have disconnecting, turning back, or resetting the odometer of any motor vehicle so as to reduce the numbers of miles indicated on the odometer gauge. So one thing I will caution on this one is I experienced it where we actually had the odometer roll. It got so many miles on it, it actually rolled on its own. And so we had to submit some information to the state, letting them know that's what happened. I'm not sure with all the digital um, odometers we have now, that's still a problem, but in some of the older cars that are still on the road, that could happen. So, but this would be, I always heard it when they crack open the odometer and roll it back. Um, so they have to manually roll it back, and that's one of the other things that's very, very easy to prove in court. If you can prove that the odometer was rolled back, it has to be rolled back on purpose. So that's going to be an intentional or knowingly doing this, which will triple your damages that you would have to pay out. So just don't do it. Just be honest as to what the mileage is on the car or vehicle that you're selling. Um, Advertising of any sale by fraudulently representing that a person is going out of business. Don't say that you're going out of business so that you get this huge sale and tons of money from the sale when you aren't, in fact, going out of business. So, one thing I will caution on this is, if we have a bankruptcy and a reformation of the business, they may actually go out of business and then come back as something else that was a very similar name to what they were operating under before going out of business. So just because you see it going out of business and then the business stays doesn't necessarily mean that they violated this, but it is something to look into to make sure that they have not. And if you're a business owner, don't just put a sign out saying going out of business because you want to get a lot of people coming in and buying your things, when in fact you are not going out of business. It's another one that's pretty easy to prove to get an intentional or knowingly tripling of the damages. Let's see, let's do one more. Advertising, selling, or distributing a card which purports to be a prescription drug identification card, which is issued under the insurance code in accordance with rules adopted by the Commissioner of Insurance, which offers a discount on the purchase of healthcare goods or services from a third-party provider, and which is not evidence of insurance coverage unless the discount is authorized under agreement between the seller and the provider. The seller does not represent that the card provides insurance coverage, and the discount is not false, misleading, or deceptive. That was a lot of words to basically say, don't tell somebody that you're providing them insurance when in fact you're not providing them insurance on healthcare. Now we have some of these prescription cards, and they're pretty clear on them as long as they have that warning on the card saying that this is not an insurance that is being provided to you. So we'll talk about some more next week. We got a few more to get through, but hopefully this is helpful just to make sure that you don't run afoul of the Deceptive Trade Practices Act and some common ways that it happens. So as always, I'm here every Friday answering any questions that I get during the week and talking about different areas of the law at 11:30 every Friday. Try to be live. Sometimes I may have to have a video if I have court. But as always, you can always send me a direct message through Facebook, or you can reach out to me at 832-919-6595, and we can get you a free phone call with me to answer any questions that you may have, no obligations. Or you can send me an email at Duana, D-U-A-N-A, at boswelltexaslaw.com, and I will get an answer out to you. And that comes directly to me. That is not my staff or anyone else answering those. So I look forward to hearing from you, and I hope that everybody enjoys this beautiful weekend that we're supposed to be having. See you next week.